very good morning to Madam Siti Fatima and my dear fellow friends. I'm Kirtana Thirumurugan. Today our group is going to explain about the Industrial Court of Malaysia, about the case between the Haridasan Ramaiah and the Ali-Koting Sendriat Berhad. So today my part is going to explain about the analysis and the summary of the cases. So I have attached a cute infographic video as an introduction of this case. So I will move on with my part. The firstly is the claimant of this case is the Haridasan Ramaiah. So the respondent of this case is the Ali-Koting Sendriat Berhad. The claimant said that claimant is also known as the production supervisor in the Ali-Koting Sendriat Berhad. So he also said that throughout his employment in this company, he was never received any written letters, written warning letters, or received any negative comments. And suddenly, he was, without any early notification, he was given a termination letter. He was surprised. The respondent was denied that, and he said that the claimant has issued with the written alerts and he was left behind of the works and he had the bad performance at the sections and the administration was not seen heeding the reminders. The respondent also said that despite the updates, there are several meetings between the February and the July 2019. Further, the claimant's work performance is going very badly and he is unable to complete his work. So, this was an early notice and the evidence of the respondent from the Department of Quality and Assurance. The claimant denied that he was charged for 2 lines for 6 months after the operation manager was left abruptly. So he said that then also he further asked to supervise for at least 5 lines before a substitution was made. The claimant said that he was unaware of any extraordinary rejections of pallets at the production level. And he also said that he was unaware of the sudden rejection of the 25 pallets at the production level. So he said that there are no discussion or meeting or elevated about the case between the rejection of the 25 pallets and the lack of the performance of his work after the Mr. Lee was left abruptly. He was the person who was took over the production supervisor's work. So during his performance or during his employment, that in the discussion also, he was not given any warning letters or any negative comments or about his work performances. But for the first time, all these things is come out in the termination letter. It was raised in the termination letter about his bad performance, about the performance of the work and many more. There is evaluation and findings of the court that I have attached a cute infographic video about these findings. Let's do watch it. So, the court arrives at having regards under Section 1305 of the Industrial Relations Act of 1967 via to act accordingly equity, conscience and substantial merit of the case. Therefore, the claim is allowed because the court finds that the claimant is not without blame. So the court cannot ignore this fact when deciding the quantum of the compensation, which is we are explaining in the evaluation and the findings of the court. So hereby the respondents are given an order to pay a sum of 32,654 ringgit and 25 cents of any last statutory deduction to the solicitor within 30 days from the date of their off. So finally, this case is won by the Haridasan Ramaya, which is known as the claimant. That's all from me. Thank you.
A very good morning to Madam Siti Fatima. I'm Saranya Jagannathan. My metric number is 4193000331. Today I'm going to explain about fact of the case, and before that I have prepared one small video which briefly explain about my part. Let's watch. Falls between Haridasan Analalaki Ramaya and Allied Coating Sdn Bhd in Industrial Court of Malaysia. The claimant in this case was Haridasan Analalaki Ramaya, whereas the respondent is Allied Coating Sdn Bhd. The fact that addressed in this case was claimant Haridasan Analalaki Ramaya had pleaded that he had begun working as a production supervisor on 9th July 2019 and suddenly was called by human resource manager and informed that it would be his last day of working, and they told him to not attend working to the following day. Then the issue addressed in court case between Haridasan Analalaki Ramaya and Allied Coating Sdn Bhd is complaint of dismissal or termination from employment of the claimant by the respondent without just cause or excuse on 9th July 2019. The claimant asserted that his dismissal was without just cause or excuse, since it is not disputed that the claimant was terminated from his employment with effect from 9th July 2019. The court has only rights to determine whether the termination was just for cause or excuse. These are the facts that I addressed from this case. That's all from me. Thank you.
Good morning to Madam Siti Fatima and my fellow friends. My name is Nityapriya Rajanathan. So today I'm going to explain on my part, which is about the act or law that are involved in the case that we have chosen. But before that, I would like to ask a question. Why is that act or law is important in a case? This is because in the terms of law, there is no specific definition for it. But it's a nature which implies that no one is above the law. It's also a way to show that everyone should comply with the law and there is a fair in our legal system. So now I'm going to explain on the first act or law that are involved, which is the Industrial Relation Act of 1967. This act is effect on the date of 7th of August in 1967, and the main purpose of this act is to maintain a good relationship between the employer, employee, and also their trade union. As for this case, the claimant had made a complaint on the respondent for an unfair of dismissal. The main key for the employer to make a dismissal is with a valid cause or excuse before terminating the employee. If they fail to do so, the employee have the right to make a complaint on the employer. Secondly, the act or law that are involved are under section 23 of Industrial Relation Act of 1967. As for this section, it can be defined as the receiving the notification of the Director General under subsection 2, the Minister may refer the representations to the court for an award if he thinks fit. As for this case, it can be seen that the award is given by the Honorable of Minister Human Resource to pursue the complaint that has made by the claimant for an unfair of dismissal by the respondent without just cause or excuses. So thirdly, the act or law that are involved are under 35 of Industrial Relation Act of 1967. As for this section, it can be said that the court shall be act according to the equity, good conscience, and the substantial merit. From this case, it can be said that there is insufficient evidence to show that the claimant had a poor performance and given an earlier warning, even though the respondent insists that he has given an earlier warning. So the court has made a judgment that the respondent needs to pay the compensation to the claimant. This is where it shows there is a fair judgment in the court. So fourthly, the act or law that are involved are under section 21 of Industrial Relation Act of 1967. As for this section, it can be said that where a common workman or whether a member of trade union make a representation in writing to the Director General to be reinstated in a form of employment. As for this case, we can say that the claimant had made a representative to the Director General for an unfair of dismissal in his workplace. Lastly is the section of 33(4) of the Industrial Relation Act of 1967. And this section can be defined as the decision of the court shall be binding in the same manner as the original award or agreement. From here, it can be said that the court has made a judgment that the claimant need to have a compensate without a re-establishment. So from all this, it can be said that all the sections of the act or law that are involved in the case that is mentioned below. So before I end my talk, I would like to say that I have prepared a small video, so I hope that you guys will enjoy with it. Thank you so much.
My name is Hemavali and my metric number is 41930000819. So today I am going to present a simple infographic video before I start my presentation. Hope you enjoy it, madam.
I'm going to present about pros and cons of this case. So let me start about it first. First, I'm going to talk about pro of this case. The first pro of this case is a company should not terminate their employees without a proper reason. They should know the termination procedure, and an employer cannot force their employees to sign the termination letter. It is very important that employees should know their rights. This case is a very big example for all the employees because they will get to know their rights. In Section 20 of Industrial Relation Act 1967, they clarified that no workers shall be dismissed without a fair cause. Secondly, we get to know about back wages. The meaning of back wages is to cover up the damages suffered by the complainant as a result of a discharge. In this case, the respondent is hereby required to pay the amount of Ringgit Malaysia 32,654 and 25 cents within the 30 days from the date of hereof. Other than that, we can reduce the unemployment rate. If the employers terminate their employees without a proper reason, and if they didn't follow the termination process, so this will make an unemployment rate will increase, because there will be many unemployees. So this will be a danger to our country. So next, I'm going to talk about cons of this case. So the first con of this case is this case will affect the company name. The company name is very important in a marketing phase. So if this case happens frequently in allied company, this will damage the company name, and the employees will be not loyal to the company, and they will change their jobs. If they change their jobs, this will make the reputation of the company will go down. So the last con of this case is it's a simple procedure to known by every company about the termination process. So the allied company didn't know how to terminate them. Will be the shame for that company. And from this case, I hope that allied company will know the simple procedure of a termination process, and they won't repeat their mistake again. Thank you.
Very good morning to Madam Siti Fatima. My name is Puvarasi, daughter of Raman. My matric number is 4193003081. Today, I am going to provide some solutions to the case in order to overcome the issue from repeating in the future for the organization. The organization can follow these steps to terminate an employee. The first step is the organization should identify and document the issue. For example, emails they have received, deliverable crates, and their weekly status report. It is important to provide evidence on today's legal world on why is someone being dismissed, so that they cannot argue that the organization fired them because of the discrimination. Secondly, the organization should coach the employee to rectify the issue. For example, the organization can have open discussion with the employee to get a clear picture about what is going wrong. By this, the organization can rectify the issue. Thirdly, the organization can create a performance improvement plan. It is prudent purpose the performance improvement plan to the employee when their work is consistently subpar. The fourth step is the organization can have regular check-ins to share if the performance is improving. In order to have input whether or not they are effectively progressing, the organization can share the input to the employee during the process. The fifth step is identify how the organization fill the gap from their role. It is suggested that when someone has to be shot, they perform so badly, and watching them walk out of the door will not always cause a major business disruption. Once recruited replacement, the organization can ask other individual or other team to cover their job. The next step is the organization can coordinate with human resource management. This is because to be prepared to continue with the nitty-gritty of firing a worker at this point on employee termination process. The organization can coordinate with human resource management to get more relevant documents and the final verification of the employee. And the next step is the organization should make the conversation quick and respectful. The meeting itself should be very short, just a couple of minutes, as soon as you sit down and get the news right away. The organization cannot engage if the employee argues. The organization should end the meeting quickly. The last step is the organization should help them to smoothly transition out. This is because the organization concluded the challenging meeting and now the organization need to help the employee to leave the building politely, and the organization can thank the employee for their effort. These are the steps in employee termination process which can follow by the organization to terminate an employee. Thank you.